when we talked a couple of weeks ago, but or last week, whenever it was. When I got the bug to learn the law because I knew something was wrong in the courts, I was working with a guy named Bill Henshaw out in California, a real constitutionalist, and I was watching your videos on YouTube, and that's how I got started.
Yeah, they're don't get me going.
Okay.
They couldn't care less about justice or anything like that. They're just,
I was wondering if you still had your administrative law channel, administrating the administrator.
Administrating your public servants?
It was, administrating your public servants. That's it.
Those are two email lists, and I still have them. There's one at Google Groups and one at freelist.org.
Freelist.org. Yeah. All right. Are you gonna upload this writ so I can follow along here, or how are you gonna do that?
Well, I was gonna show it on the screen while we're talking about it.
And then make a link to it, maybe somewhere down the line.
Yeah, I could upload it.
Okay, great.
Yeah, Glenn has a room in here, just like the general chat, and he usually uploads everything to his room. So I make sure I get him to do that.
Gotcha. Mm-hmm. All right. Well, I look forward to listening to you, Glenn. It's good talking to you again.
All right.
I got the Bevins up if you want me to do that now.
Yeah, why don't you go ahead?
Okay, here we go. 3 times. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, great. Number 2, maybe Glenn, if you could mute so there's not a backseat. I don't know if anybody else is getting it. There we go. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Awesome. It looks like we're all clear. And I'll take open this up with a small prayer. Holy Father, please bless our meeting with eyes to see and ears to hear the messages and info being presented, with an open and caring and compassionate heart for all of our fellow brothers and sisters, as it may be done. Take it away, Glenn.
Okay, there's some people talking about sound on YouTube. How's the sound now? Is it any better?
It sounds perfectly clear.
Perfectly clear.
Okay. All right, good. Okay. Well, this is my petition for writ of certiorari. This is an emergency petition. I made it big so you can see it. So you can read the text on YouTube. Okay, they're saying that my sound is better, so good. And so I'm going to just go through it. It's 39 pages, but that's including the table of contents, and technically the table of contents isn't included in the page count, so it's actually probably 37. So it's got to be under 40 pages. I had to mess with it to get it less than 40 pages. It has to appear to be double spaced, so technically it's 1.5 spaced. And then they also recommend the font, and so I'm using the font that they want. I mean, it's under their rules. And so usually what will happen is I'll send this to the clerk, and then they'll probably send it back and tell me what I need to fix. But they're usually pretty helpful. Anyways, so this is I'm gonna do this as an emergency petition. So I'll just read the thing, and you'll see what I'm doing and what I did as far as everything up to now. So the petitioner converted silver to land on the land of Texas in 2021, stated on the face of the deed that the petitioner failed to be a U.S. citizen or Cestacate Trust, true copy of which is attached here too in the appendix, all of which is incorporated herein by reference in its entirety. So the deed is going to be in the appendix. So there's going to be an appendix. I have to make a table of contents. I actually do have a table of contents. There'll be an appendix, and it says in the rules that it's supposed to be printed on both sides of the page, so that means less paper. So that's good. The County of Montague Municipal Corporation, in the direction of the Texas Controller and in conspiracy with the Pope's private bar guild, rendered by force the petitioner's land, thereby converting the petitioner's land from the land of Texas to the Pope's owned and operated foreign district of Columbia under the Commerce Clause. The County of Montague Municipal Corporation proceeded to enslave the petitioner with their minor estate, 31 CFR 363.6, with their tax notices, tax liens, and threat letters. The petitioner served by registered mail a Catherine Phillips notice and demand to the leaders of the Pope's Municipal Corporation, explaining that they were engaged in multiple felonies and that the petitioner failed to be a U.S. citizen or Cestacate Trust, demanding that they produce a bona fide contract, a true copy of which is attached here to in the appendix, all of which is incorporated herein by reference in its entirety. The County of Montague Municipal Corporation got the Pope's private bar guild members to file a tax suit in the 97th District Court before the Pope's bought and paid clergy, Patricia Coleman Byers. The petitioner filed 78 criminal complaints into the case and sent them to the Federal Bureau of Investigation, and the United States Attorney and the weaponized Department of Justice ignored them, as well as Byers. The Pope's bought and paid for clerks masquerading as judges, clergy in the 97th District Court issued a bill of pains and penalties similar to a bill of attainder with their legislative act against the petitioner, the named individual, and assaulted the petitioner with the Pope's minor estate to justify the theft of the petitioner's land by the County of Montague and their private bar guild handlers, and enslaved the petitioner for their Vatican handlers. And they're in process of selling the petitioner's land when, on the day of the sale, the petitioners set off their extortion with their Federal Reserve note commercial paper fake money that are only for use in the Pope's foreign-owned and operated District of Columbia. And this is Gold Reserve Act of 1934, As used in this act, the term United States means government of the United States. The current currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. The petitioner has never in his life breached the peace, but the Pope's Federal Bureau of Investigation Military Police refused to investigate the felonies, and the Pope's United States Attorney refused to prosecute the felonies that the County of Montague Ecclesiastical Municipal Corporation and conspiracy of the Pope's private bar guild members had engaged in. And I ought to change that to support their weaponized Department of Justice and their communist handlers. The petitioners filed bar grievances against 98 members of the Pope's private bar guild, some more than once, and they were all dismissed as an inquiry. The petitioner appealed all the dismissals to the Board of Disciplinary Appeals, and they got dismissed again. All this originated with the Ecclesiastical Municipal Corporation established by Congress at 12 Stat 419, which is now owned and operated by the Pope. The petitioner filed a lawsuit in the Fort Worth Federal Court, and they issued the findings, conclusions, and recommendations of the United States Magistrate Judge, which fails to be a required findings of facts and conclusions of law, which means it has nothing to do with facts or law, which means they're legislating from the bench, and it's a bill of pains and penalties, similar to a bill of attainder and unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. True copy of which is attached here to in the appendix. The petitioner filed document 104, notice of objection to the magistrate findings, conclusions, and recommendations, and motion to reconsider. True copy of which is attached here to in the appendix. The court filed an order accepting findings, conclusions, recommendations of the United States Magistrate Judge, filed 21st of February 2025. True copy of which is attached here to in the appendix. The court filed a final judgment, filed 21 February 2025, a true copy of which is attached here to in the appendix. The petitioner filed a notice of appeal on 3 March 2025, and it's in the U.S. Court of Appeals for the Fifth Circuit, case 25-10360, a true copy of which is attached here to in the appendix. Petitioner filed document 108, notice of constitutional challenge, on 10th of March, a true copy of which is attached here to in the appendix. The petitioner filed document 112, mandatory judicial notice of 12 presumptions, certified copy, filed 30th of May 2025, a true copy of which is attached here to in the appendix.
That was me emailing or texting you. You're not screen sharing.
You got a point there. Okay, I'll let you have that one. I'm glad you're reminding me. Here we go. How's that?
Now it's good. Yeah, perfect.
Now let me just make sure what's coming through on YouTube. It's actually, I have the Word file that's showing up on YouTube. Okay, thank you very much for letting me know. Okay. So the petitioner filed document 113, affidavit of life, certified copy, filed May 25th, 2025, a true copy which is attached here to in the appendix. The petitioner filed document 114, notice of void judgment, 30th of May, 2025, a true copy of which is attached here to in the appendix. So all of that stuff is going to be in the appendix. Statement of jurisdiction. So these are these major categories right here, statement of jurisdiction, and let's go up to the top here. So summary of the case, statement of jurisdiction, constitutional and statutory issues involved, statement of the case, and then the conclusion. Those are all categories that are in the rules. So they want to see all that stuff in the rules. It's all called out in the rules. So anyways, Article 1, Section 1 of this Constitution for the United States of America says all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And Article 1, Section 8, Clause 9 says to constitute tribunals inferior to the Supreme Court. And since this court was created by the Judiciary Act at 1 Stat 77, the one Supreme Court talked about in Article 1, Section 8, Clause 9, and Article 3 can only be talking about a common law court that existed prior to the Constitution, because this court is a legislative inferior court created by under Article 1, Section 8, Clause 9. This petition for writ of certiorari was brought pursuant to Article 3 of the Constitution for the United States of America, that provides the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So the Supreme Court of the United States that sits in the District of Columbia is actually an inferior court. Anyways, I'm sure they'll love to hear that. This petition is brought as an emergency petition pursuant to Rule 11. This action should be a petition for writ of error, but your clerks insist on assaulting the petitioner with the Pope's District of Columbia Codes, Rules, and Regulations under color of law, which is objected to on and for the record. This action was brought in the lower courts because of an act of the United States Congress, because taxation of land originated with the act of Congress acting under executive authority 3 months after Lincoln ordered Congress to reconvene with Executive Order Number 1 on 15th of April, 1861 at Chapter 45, approved August 5th, 1861 at 12 Stat 292. Okay, that's where the act that caused all this stuff. That has not been repealed or modified, and that provided for tax assessors and collectors at Section 9 at 12 Stat 296. They're required to execute a bond at Section 10 at 12 Stat 296. They have an oath of office at Section 11 at 12 Stat 297. Secretary of Treasury to provide regulations at 12 Stat Section 12 Stat 297. A direct tax on lands and lots of ground, Section 13 at 12 Stat 297, a Board of Assessors at Section 25 at 12 Stat 300, tax liens at Section 33 at 12 Stat 303, and every collector shall it be exercised or be guilty of any extortion or oppression under color of this act shall be liable at Section 43 at 12 Stat 307, and the penalty for taking a false oath, perjury of oath at Section 47 at 12 Stat 308. And there shall be allowed in full compensation of their services a commission. Okay, so they want to go and extort as much money as possible because that's how they make their money. Section 48, 12 Stat 308. This is an emergency petition because this has national importance due to the fact that almost every city, town, county, state, and union are now operating the Pope's ecclesiastical municipal corporations and assaulting almost all of the people, if not all of the people in this country, with the Pope's minor estate, 31 CFR 363.6, and the Pope's private bar guild, all of which is evidenced by the weaponized courts that Trump is trying to get rid of with his weaponization working group in the Department of Justice. Constitutional and statutory issues involved. The 1871 municipal corporation created by Congress at 16 Stat 419 is an unconstitutional violation of Article 1 and Amendment. And notice I call it Article 1 and Amendment because that's how it's called. Okay, it's not the First Amendment. Okay, if you call it the First Amendment, then that's not really what it is. Anyways, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because it is a law respecting the Pope and the Vatican and the Holy See, and also because they're busy subjecting the petitioner to their satanic religious ceremony with their fraud, deception, lies, idolatry, and necromancy in violation of the petitioner's sincerely held Christian religious beliefs. The minor estate at 31 CFR 363.6 is unconstitutional because it was created by the Pope and in violation of Article 1 Amendment. The National Bar Foundation with all of their subsidiaries are all unconstitutional violations of Article 1 Amendment because their head office is located in the Pope's owned and operated ecclesiastical city-state called the City of London, which means it's owned and operated by the Pope. The judgment of the 97th District Court, as well as the judgment of the Northern District of Texas, are each a bill of pains and penalties, which are prohibited under U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. They're bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, and they're giving aid and comfort to the enemy in a time of war in violation of Article 3, Section 3, Clause 1. Statement of the case. The petitioner's mother and father were joined in the state of holy matrimony at the time the petitioner was born of him, and all of his ancestors were joined in the state of holy matrimony as evidenced by the statement of original status in the affidavit of corporate denial. It was recorded with the Pinal County Recorder at fee number 2013-032373, and the pedigree charts that are attached thereto. That is now the unrebutted truth and public policy, which may be viewed at their website. And Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey. 1787 is the petitioner's fourth great uncle, which means the petitioner's posterity is found in the preamble, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Secure the blessings of liberty to ourselves and our posterity. And the petitioner is entitled to right of blood. And right of blood cannot be destroyed by any civil law, because all the laws of Congress after 1871 and all the laws of Texas after the Civil War are civil laws. And this is a maxim of law, Bouvier's Law Dictionary, 1856 edition, page 768. The right of blood and kindred cannot be destroyed by any civil law. And this court is operating under power which is derived from the petitioner as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. That's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the petitioner to give the Pope's County Montague or their private bar guild handlers or this court any authority over the petitioner, and the Legislative Inferior Supreme Court of the United States agreed and said it's impossible to confer a sovereignty which will extend over the petitioner. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority, is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers were not given by the people of a single state, they're given by the people of the United States, to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. The petitioner is exempt from the Pope's County of Montague and the Pope's private bar guild, quote, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's Cowan&Co. versus Polyblank, U.S. Supreme Court, 1907. And the petitioner requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land, quote, anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2. And we, the people, failed to be U.S. citizens because the Pope's 14th Amendment U.S. citizen failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state. As such, after the Union had commenced, and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. The Pope's 14th Amendment U.S. citizen is a fiction of law. It might be correctly said there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be called a citizen of the United States, although technically and abstractly there is no such thing. And this is actually a quote from Public Law 100-418, August 23rd, 1988. The term United States business means a United States citizen. It's a corporation. The Pope's 14th Amendment U.S. citizen is created by now what is owned by what is now the Pope's owned and operated Congress under the Pope's canon law. The 14th Amendment referred to slavery. Consequently, the only persons embraced for its provisions for which Congress was authorized to legislate were those in the manner were those then in slavery. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, convey real and personal property. That's currently the current 42 U.S.C. 1982. Fictions of law. Fictions of law were invented by the Roman praetors under ecclesiastical canon law for the Pope's ecclesiastical city-states, which is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, page 520. Fictions of law were invented by the Roman praetors who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the source of weakness, which, in order to obtain its object, assumes as a fact that which is known contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. So they're legislative. Fictions of law owe their origins to the legislative usurpations of the bench. And so it's a legislative usurpation of the bench. The fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And that's U.S. versus Lovett. Bill of attainder, legislative act, no matter what their form, that apply to either named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. Bill of attainder talks about, there's a couple other sites here. A legislative act that, though similar to a bill of pains and penalties, is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is capital punishment. Bill of pains and penalties is anything less than capital punishment. Because judges only hold office during good behavior, the judges both of the Supreme and Inferior Court shall hold their offices during good behavior. Article 3, Section 1. And judges in bad behavior, which is fake judges, are engaged in fraud upon the court. Fraud upon the court is fraud which is directed to the judicial machinery itself, and is not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, where the impartial functions of the court have been directly corrupted. Derogating common law. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction. It is familiar law when special statutory authority in derogation of common law is conferred on courts of general jurisdiction. Such a court of general jurisdiction becomes quad hoc, and quad hoc is Latin for the purpose of this proceeding only, a court of inferior or limited jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. And that's Book 21, Corpus Juris Secundum, Courts, Section 2. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. And that's Book 20 of American Jurisprudence, 2nd edition, Courts, Section 103. The judges dealing with the Pope's minor estate are the Pope's clergy. This is, yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Pope, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted to not to themselves directly, but to nominal fiefs, to the use of the religious houses, the Vatican, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to assist the use for the rents and emoluments of the estate. That's called taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses, which is short for usufructs, and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And engage in fraud upon the court, in conspiracy with the Pope's private bar guild members working for the Pope's County of Montague Ecclesiastical Municipal Corporation when they issue a bill of pains and penalties against the petitioner, the named individual, to be accomplices to the theft of the petitioner's land by using the ecclesiastical fiction of law, minor estate, sestque usufruct. The Pope's forced rendition. The County of Montague Ecclesiastical Municipal Corporation converted the petitioner's land from the land of Texas to the Pope's owned and operated foreign United States by rendering by force the petitioner's land, even though the Texas tax code, originating after the Civil War with an act defining what money and property is subject to taxation or exemption and the mode of listing the same on August 21st, 1876, Section 1, be it enacted by the legislature and state of Texas that all real and personal property in the state, the property of corporations now existent or may hereafter be created, and the property of all banking or banks or banking companies now existing or may hereafter be created, and all bankers, except such as hereinafter expressly exempted. Okay, so that's who is corporations, which is for corporate-owned property. In Section 4, the term person, whenever used in this act or any other act regulating assessment and collection of taxes, shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes. And the Section 104 definitions, Texas Tax Code, market value means the price at which property would transfer for cash or its equivalent under prevailing market conditions. And as explained in the Catherine Phillips Notice and Demand 06-1022, which was served on the Popes County of Montague, that shows the taxable land is used for the production of income. And rendition. It says, a person shall render for taxation all tangible property used for the production of income. And rendition originated with Article 7 of the Act of the Legislature of 1876. And this is Article 7, all property shall be listed or rendered in the manner following for every person being a resident of the state, which is corporate property, which means the petitioner's land fails to qualify for petition for rendition, as explained in the Notice and Demand that was served on the Popes County of Montague, because income is corporate profits. And this is Eisner versus McComber, emphasis in the original. Okay, so all this underlining here was in the original. You go look it up and it'll all be underlined in the actual law book. Becomes essential to distinguish between what is and what is not income, according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot, by legislation, alter the Constitution from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Here we have the essential matter. Not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested and employed, and coming in and being derived, which is derived and drawn by the recipient for his separate use and benefit and disposal. That is income derived from property. Nothing else answers the description. The Pope's ecclesiastical city-states in Italy. After the collapse of the Roman Empire, the Pope was absolute monarch of a group of ecclesiastical city-states on the Italian peninsula. And this is taken from Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy in the northwest, and Naples in the southeast. Area 17,822 square miles. Population in 1833, 2,742,000. Capital Rome. Population 153,000. Government and elective monarchy. The Pope, for the time being, the absolute sovereign with a consulting assembly of cardinals. Rome, the capital of the Pope's territories of Italy, anciently the Milrus of the Roman Empire. And that's Encyclopedia Britannica, 1773, volume 3, page 632. With the law being Roman law is also called canon law, and ecclesiastical and municipal law and civil law, the laws of the municipia or dependent states. And this is Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771, volume 2, page 883. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states, but it became by degrees to signify all civil laws without distinction. No sovereign state can subsist without a supreme power or a right of commanding in the last resort. The supreme power of one age cannot therefore be fettered by any enactment of a former age. Canon law, or body of canon law, collection of ecclesiastical rules, definitions, and constitutions taken from the ancient councils, writings of the fathers of the church, and the ordinances of the popes. This law is modeled according to the form of the Sibyl, and contained 3 particular volumes: the decrees of Gratian, the Decretals, and the Sextum, which see And that's 1720 Phillips, A New World of Words. Civil law, Roman civil law are convertible phrases being the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, distinguish it from the law of nature and from international law. The civil or Roman law is also called canon law, the civil or Roman and canon law. So there's the Encyclopedia Britannica, Volume 2. They're calling it civil or canon laws, okay? So civil and canon are interchangeable. And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in 1870, a year before the Pope's 1871 municipal corporation was enacted by Congress. In the year 1198, Cardinal Locarius was chosen Pope and took the name of Innocent III. And this is modern part of an universal history, the earliest account of time compiled by the original writers, page 430, 1761. The history of Italy, AD 1198, Cardinal Locarius is chosen Pope and takes the name of Innocent III. He receives allegiance from the prefect of Rome and requires homage from all in the ecclesiastical state. And in the year 1213, King John gave the kingdoms of England and Ireland to the Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And this is, and not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. So the Vatican owns the kingdom, owns England. With the concessions of England to the Pope in 1213, we will and establish perpetual obligation and concession. We will establish that from the proper and special revenues of our aforesaid kingdoms, from all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and at Easter, 500 marks. 700, namely for the Kingdom of England, 300 for the Kingdom of Ireland. And that's concessions of England to the Pope, 1213, which means the Pope owns the Kingdom of England and Ireland, now known as the United Kingdom, the Crown, and the City of London. The Pope's Sesquice V Act of 1666 caused the War of Independence. The Pope's dependent city-state in the City of London, called the Crown, created the Sesquice V Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Pope, folks. That's that previous site that I read from Tomlin's Law Dictionary. Who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to assist use for the rents and emoluments of the estate, which means the Pope's clergy were the judges in the ecclesiastical and municipal law courts, which is what precipitated the War of Independence, as evidenced by the cause of necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. And the organic law, the Declaration of Independence, shows it was listed as reason for Declaration of Independence from the Pope's tyrant, the Crown of England. He's combined with others, that's the Pope, to subject us to a jurisdiction foreign to our Constitution, that's Roman law, and unacknowledged by our laws, Roman canon law, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. Gee, that sounds like what's going on today. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, the others is talking about the Pope. And the foreign jurisdiction is the Pope's ecclesiastical Roman civil law. And the definition of, and the definitive Treaty of Peace of 1783 in the preamble, it says King George was arch-treasurer and prince-elector of the Holy Roman Empire. evidencing the crown of England was owned and operated by the Pope as arch-treasurer and prince-elector of the Holy Roman Empire. He was authorized to make peace on behalf of the Pope, which is also why thousands of people were fleeing Europe at that time, because the Pope's tyranny there, as talked about in John Locke's Two Treatises of Government. The Pope's tyranny is the exercise of power beyond right, which nobody can have a right to, and is making use of power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and commands and actions are not directed at the preservation of the properties of his people, but the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion, 'tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that, for wherever the power that's put in any hands for the government of the people, the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Sections 199 and 201. With the Spanish Inquisition, Inquisition is one way of proceeding with ecclesiastical courts and other inquisitions and oppressions they routinely engaged into. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, as to continually harass and shamefully enrich the Pope's crown. That's Book 4 of Blackstone's Commentaries. Courts ecclesiastical, spiritual courts, are those courts which are held by the king's authority as the supreme governor of the church, for matters which chiefly concern religion, and the laws and constitutions whereby the Church of England are governed, diverse immemorial customs in our provincial constitutions, and the canons made in convocations, especially those in the year 1603. Much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. That sounds like stuff that went on with Trump recently. And also why the petitioner's ancestors made the first article and amendment: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they did not want it happening here. When they're talking about pretended legislation and pretended offenses in the Declaration of Independence, he's combined with others to subject us to a jurisdiction to our unacknowledged, giving his assent to their acts of pretended legislation, transporting us beyond seas for pretended offenses. Yeah, let's underline that. They're talking about the Pope's ecclesiastical Roman canon civil law. Canon law is a body of Roman ecclesiastical law relative to such matters as that church either has or pretends to have the proper jurisdiction over. And that's Bouvier's Law Dictionary, 1856 edition, volume 2, page 8. Canon law and body of canon law, a collection of ecclesiastical rules, definitions, and constitutions taken from ancient councils, the writings of the fathers of the church, and the ordinances of the popes. This law is modeled according to the form of the civil, contained in 3 particular volumes. There are lots of references in these old law dictionaries to the Pope's pretended jurisdiction. Jesuits, born in the king's dominions and ordained by the pretended jurisdiction of Rome, remaining in England or coming beyond sea. Oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. The Pope's clergy operate under ecclesiastical Roman civil law courts with a private bar guild, with bar being acronym for British Accredited Regency. Regency is an officer jurisdiction of a regent or body of regents. Because the Pope's private bar guild clergy members are appointed by Inns of Court. And that's Inns of Court, certain private unincorporated associations, nature of the collegiate houses located in London, invested with the exclusive privilege of calling men to the bar, which is located in the Pope's dependent city-state, located in the city of London, originally called the Kingdoms of England and Ireland, now known as United Kingdom and the Crown, since concessions of England to the Pope, 1213, which means all private bar guild clergy members are foreign agents of the Pope, which is why they're here under the Pope's civil laws of Congress, foundation of the Federal Bar Association and the Code of Law for the Pope's District of Columbia, now known as Title 35, U.S. Code, Section 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945. There is a reason to believe the Pope's Crown of England orchestrated the War of 1812 to facilitate the disappearance of the true Article 13 and Amendment. And this is the Article 13 and Amendment. Because one of the major engagements was when the Pope's owned and operated British Army went to the capital and burned the National Archives, which is where the ratifications records would have been kept. The petitioner has seen the same Article 13 Amendment taken from Colorado statutes in the 1850s, and there's reason to believe that Lincoln might have used the Civil War to facilitate his disappearance, because Lincoln was one of the Pope's private bar guild members, and he would not be qualified to hold office with it in place. And there's a statue of Lincoln in the Pope's owned and operated city of London. The Pope was involved in the Civil War because the Pope's owned and operated Crown of England sent fleets of ships to attack Washington, D.C. and San Francisco in support of the Southern Confederacy, but the Russians sent fleets of ships to blockade the area in support of Lincoln. The judges in the lower court are private bar guild members, and as required by the Pope's civil laws of Congress, called the Civil Code of Law for the District of Columbia, now known as Title 28, United States Code, Section 631, and have exposed themselves to be the Pope's clergy. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on the 15th of April, 1861, on emergency and necessity and executive authority with Executive Order Number 1 at 12 Stat 1258, Lincoln ordered Congress to reconvene. And everything's been under the Pope's executive authority ever since. The Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the Supreme Court, which resulted in Rule 45, which is in place to this day. Rule 45, all process of this court issues in the name of the President of the United States, which means there's really no separation of powers. And when Obama was trying to get Obamacare passed, the courts were calling it unconstitutional. And Obama came out and spoke publicly against the courts. And when it got to the Supreme Court, they fell right into the line, did what they were told, and approved Obamacare. The Pope's 1871 Ecclesiastical Municipal Corporation. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870. The year prior to the Congress's 1871, a municipal corporation. And this is Wikipedia. The formerly Republican leader of southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870. Isn't that convenient? Completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy, and are now called Vatican City and the Holy See, and it continues to this day. And this is the Lateran Pact of Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. The Pope's ecclesiastical Roman canon law, Sestike Ius, was brought into the United States first with the Pope's 1871 Ecclesiastical Municipal Corporation at 16 Stat 419, because civil law, Roman law, and municipal law are convertible phrases, and because municipal law was the laws of the municipia, or dependent papal ecclesiastical city-states. And that's this here, Encyclopedia Britannica, 1771. Pope's Sestike V Act of 1666 was brought into the United States with the Code of Law for the District of Columbia in 1901. Chapter 854, an act to establish a Code of Law for the District of Columbia and the legal estate to be the Sestike Ius. The Pope's minor estate, Sestike Usufruct, now codified at 31 CFR 363.6, are unconstitutional because Article 1 an amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, cestike use, which is a usufruct, which is now called the minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And this is 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in their Treasury direct account. The Pope's cestike use, minor estate, 31 CFR 363.6, is a fiction of law which was invented by the Roman praetors under the pretense of doing equity, and no other origin to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy, and they're satanic. There shall not be found any among you that maketh his son or his daughter to pass through the fire, that useth divination, or observer of times, or an enchanter, or a witch, or a charmer, or a consultant with familiar spirits, or a wizard, or a necromancer. For all these things are an abomination unto the Lord. Because of these abominations the Lord thy God doth drive them out before thee. And that's Deuteronomy 18:10-12, King James Version. And put you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17, to exercise exclusive jurisdiction whatsoever over such district, not exceeding 10 miles square, as may by cession of particular states and acceptance of Congress become the seat of government. There's two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's dissenting opinion, Downs versus Bidwell. The Pope's quasi-contracts, they use fraud and deception to assault people with a quasi-contract, a fake contract, with a subset. Both in Roman and English law, there's certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of this fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Pope's fiction of law, minor estate. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law, because under the Commerce Clause, the boundaries of the Pope's District of Columbia, and through their plenary power nationally, covers those citizens, even one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for the Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And Kavanaugh said, yes, you can. And because plenary power is a dictatorship under the Pope's Roman civil law, plenary as the courts of admiralty and English ecclesiastical courts, plenary is a complete and absolute power to take action in a particular issue with no limitations. Plenary power. And this is Legal Information Institute. Complete power over a particular area with no limitations. This term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. The judges in the lower courts are tyrants operating as bought and paid for administrative legislative clerks masquerading as judges. The Pope's clergy under the Pope's canon law of trusts and bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute is involved, the Pope's fake judge is actually a clerk, masquerading as a judge as the Pope's clergy. When acting to enforce a statute and the subsequent amendments of the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a ministerial clerk for an agency, judges have become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. which means they're legislators engaging in legislative acts against the petitioner, the named individual, by using the minor estate, which is a fiction of law, which is invented by the Roman praetors under the pretense of doing equity and owe their origin to legislative usurpations of the bench, which means that Patricia Coleman Byers, fake judge of the Pope's 97th District Court, and Hal R. Ray, in conspiracy with Reed O'Connor, the fake judges in the Pope's United States District Court for the Northern District of Texas, acted as legislators, issuing a bill of pains and penalties against the petitioner, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and also Article 1, an amendment which says Congress shall make no law respecting an establishment of religion, because it is from the Pope's Roman law, also known as canon law and ecclesiastical law, and they're also bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. Like colonial days, they've imposed the Pope's martial law, which is why we took up arms in 1775. Like with Roosevelt's New Deal and a bankruptcy emergency, its established fact, the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, and that's U.S. Congressional Record. And this is U.S. Senate Report number 93-549. Since March 9, 1933, same date, notice the date, March 9, 1933. The United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel and a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. Martial law rule is a law of emergency and necessity. There's three kinds of martial law. Full martial law, when actually invaded by a foreign enemy or insurrection, troops put on the straight. Martial law proper is law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martials. And martial law rule, the law of emergency and necessity. It's used during peace times, can go on indefinitely. And that's taken from Ex parte Milligan and also Diet versus Turner, and it's found in the non-ratification of the 14th Amendment by Judge A.H. Ellard of the Utah Supreme Court. The private bar guild is here to enforce the martial law rule for the Pope, and the Pope's bar guild clergy members on the bench tell you I can do anything I want in this court. And this is another cite from Diet versus by non-ratification of the 14th Amendment. This is a war over the intrusion of the civil law upon the common law, and the court in Diamond v. Harris calls the civil law superior equity. And here's the Diamond v. Harris cite. It's difficult to see how courts of the state are to ignore the common law as rule of decision when it's made so by statute and adopt the civil law even though it have the merit of superior equity. In the meantime, civil law was a form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. Because normally equity follows common law, which is taken from the Holy Bible, but under the Pope's martial law rule, there is no common law because it's superseded and replaced. And it's also talked about in the Causes and Necessities for Taking Up Arms, 1775. Every system of law known to civilized society generated from or had as its components one of three well-known systems of ethics: pagan, Stoic, or Christian. Common law draws its subsistence from the latter. That means Christian. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and a rule by which all legal controversies are settled. And this is Strauss versus Strauss, a divorce case, which makes it satanic. And the Pope's private bar guild clergy Satanists are using the Pope's ecclesiastical canon Roman civil law of capitis diminutio maxima, loss of status, the use of capitalization, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage when he became a slave. swept away all the rights of citizenship and all family rights. Under the Commerce Clause, Article 1, Section 8, Clause 3, to assault people with their penal action for breach of quasi-contract. Penal action is an act on a penal statute, an action for recovery of penalty by statute, where an action is founded entirely upon a statute. The only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penalty, penal, and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed by the state for a crime or offense against its laws. The noun penalty is defined forfeited to be forfeited for non-compliance with an agreement, which is pecuniary punishment for non-compliance with an agreement. Okay, see here, corporal or pecuniary for non-compliance with an agreement, all tied to the Pope's ecclesiastical Roman civil law and the Pope's quasi-contract ecclesiastical pecuniary cause. A pecuniary cause such as arise either from withholding ecclesiastical dues or the doing or neglecting of some act relating to the church whereby some damage accrues to the plaintiff towards obtaining satisfaction forthwith, he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtracting and withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy. There's all these Baal priests with these black robe uniforms in the so-called courts or clergy, as pensions, mortuaries, compositions, and the like. And that's Book 3, Blackstone's Commentaries. And that's also taken from Holthouse, A New Law Dictionary. To populate the Pope's prisons by selling people into slavery. He, the prison, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. The Pope's clergy are priests of Baal, and the lower so-called courts are subjecting the petitioner to their satanic religious ceremony for their fraud, lies, deception, necromancy, and idolatry. In violation of Article 1 and Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, that the Pope's Federal Bureau of Investigation refuses to investigate, and the Pope's United States Attorney refuses to prosecute. With their weaponized Department of Justice, it should be renamed the Department of Justice, because they intend to engage in war crimes in violation of Article 3 of the Geneva Convention relative to the protection of civilians in a time of war of 1949, by taking reprisals against the petitioner for political beliefs and religious beliefs, evidencing that the Pope's owned and operated United States has no intention of prosecuting anyone for war crimes unless it happens to fall within their political agenda. Trump even paid off the Pope when he commuted Roger Stone's penance, or sentence, which is penance, which was changed into a sum of money to be applied for pious uses, which is the usufruct. Penitentiary is meant a penitent, ordainer of penitence, a place for penitence. Penance, a punishment imposed by a crime by the ecclesiastical laws, is an acknowledgment of the offense. Penance may be changed into a sum of money to be applied to pious uses called commuting. And because the administrative legislative process under the Pope's Roman civil law, there are more people in prison in Texas as a percentage of the population than there are in communist China or the Soviet Union or the worst dictatorship in history. If there were any Christians here, the Pope's private bar guild clergy Satanists selling people into slavery would be getting their necks stretched. If a man be found stealing any of his brethren of the children of Israel, maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocent Project estimates that 60% of prisoners are innocent. But it's such good business for the Pope and their ecclesiastical Roman civil law so-called courts, which are one of the grievances of the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. All of this has been planned and orchestrated by the Pope from the beginning of this nation. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. Because the Pope is responsible for the War of Independence, and the Pope is responsible for what's happening today. The Pope nouns and operates the bankrupt 1871 ecclesiastical municipal corporation, because when any corporation goes bankrupt, it gets seized by the creditors, as evidenced by the Roman Achaea military staff that's carried in battle by all Roman commands and planted on all conquered nations, that is sitting on the right side of the speaker's podium, and 2 Roman fascia, bundle of rods bound into weapon, symbolizing under the rule of a single man, are on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers. And here's the image. There's the Roman Achaea military staff, and these are the 2 Roman fascias. That there is the Speaker's podium in the U.S. House of Representatives. In God we trust. I always wonder, which God is that? All of which evidences the fact that the 1871 Ecclesiastical Municipal Corporation, a 16 Stat 419, currently operating in the District of Columbia, is the Pope's dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state and criminal matters that talks about concurrent jurisdiction in other states, which means other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And this is a quote from the letter. It says, when the same matters are prosecuted in other states, the provisions in force in Vatican City on concurrent jurisdiction shall apply, which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, fiction of law, and the Pope's fictitious quasi-contract. And the Vatican's Pope Francis came and addressed his own and operated Congress on the 24th of September 2015, and the Pope's satanic private bar guild clergy member assaulting people like the petitioner with their ecclesiastical fiction of law, minor estate, sestike, usufruct, trust, necromancy, with presumptions of jurisdiction, presumption of the office of trustee, because the sestike, usufruct, minor estate, and the presumptions of suretyship. The petitioner has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, which is why they've targeted the petitioner with their targetedjustice.com website agenda. As posterity, the petitioner is entitled to common law, not Roman canon law, by right of blood, as found in Article 6, Clause 2 of this Constitution for the United States of America, the supreme law of the land, and also in the Judiciary Act, saving to suitors in all cases the right of common law remedy where common law is competent to give it. That's 1 Stat 77, 9, Section 9A. And the Judicial Code of 1911 of all cases in admiralty, maritime jurisdiction, saving to suitors in all cases the right of common law remedy where the common law is competent to give it. 36 Stat 1161. All debts contracted and under Article 6, Clause 1. All debts contracted and entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Because the Northwest Ordinance was adopted just 3 months prior to the Constitution, which means the nature of jurisdiction in federal territory, and Section 14 of the Northwest Ordinance, it's hereby ordained and declared the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people, and the states in the said territory, and forever remains unalterable unless by common consent. The inhabitants of said territory shall always be entitled to benefits of writ of habeas corpus and of the trial by jury and judicial proceedings according to the course of common law. Because law of the land phrase is convertible with the phrase common law, and that's a cite from 16 American Jurisprudence. When I upload this thing, you can read it if you want. And common law and the law of the land has always been here long before the government was here. And that's Hale versus Hingle. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. And because the Pope's maritime codes only apply on the high seas up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave, Article 1, Section 8, Clauses 17 and 18. Let's see what's going on YouTube. Okay, well, let's see. Okay, we'll keep going. The petitioner has been very vociferous about being posterity is found in the preamble, a living man, a living soul, in every document filed into the case, evidencing the prejudgment on behalf of the Pope's private bar guild members on the bench, the Pope's clergy, and their Vatican handlers, because it fails to matter what the petitioner says or does. This case was prejudged from the beginning using trust law by the Pope's clergy because trusts are things and fail to have rights, and the Pope's clergy can and do anything they want. The petitioner demanded the Pope's County of Montague to produce a bona fide contract or be guilty of the felonies in the Catherine Phillips notice and demand, a true copy of which is in the appendix, and they failed to produce any evidence of the bona fide contract or even answer. And the Pope's clergy in the lower court failed to produce a contract. It's impossible to prove jurisdiction absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictions supporting claim that supposed jurisdiction exists must appear on the record of the court. All courts are required to presume no contract exists because none have been produced to this day. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3rd, 1940, 54 Stat 178, says in the preamble, whereas it's desirable that the sovereign citizen of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And as affirmed by Harold M. Stevens, Chief Judge of the United States Court of Appeals for the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in the determination of pertinent national policies? Which means the Pope's County of Montague ecclesiastical corporate ringleaders are engaged in treason to the Republic, as well as the Pope's clergy, Patricia Coleman Byers, Hal R. Ray, and Reed O'Connor. And the Pope's private bar guild members are giving aid and comfort to the enemy in a time of war because we were attacked by the communist Chinese, the Venezuelans, the Cubans, and the Serbians and others in the 2020 election theft and the fake pandemic, and the forced medical experiments with their communist agenda to implement the first plank of the Communist Manifesto, the elimination of private property rights with their theft of the petitioner's land. Roosevelt's New Deal was treason because he declared bankrupt within 3 days of taking office, and the bankruptcy abrogated the gold clause, no lawful money, HGR 192, dated June 5th, 1933, and converted the United States over to the Pope, a foreign enemy that has been making war on us from the beginning. The Pope's clergy, Patricia Coleman Byers, Hal R. Ray, and Reed O'Connor, and the Pope's County of Montague Ecclesiastical Municipal Corporation, and the Pope's private bar guild members, as well as the Pope's weaponized Federal Bureau of Investigation, as the Pope's weaponized Department of Justice, and the Pope's Obama administration and the Pope's Biden administration are making war on we the people and the Republic, just like the Pope's crown did, which precipitated the War of Independence. He's abdicated government here by declaring us out of his protection and waging war against us. The communists and the Pope's FBI made war on the Republic by using sovereign citizen as a buzzword for persecution and prosecution, and then to circulate numerous news releases stating that all sovereign citizens are terrorists, as found in an ABC News article entitled Sovereign Citizen, Terrorism Assessment Warns Rising Threat from Anti-Government Extremists by James Thomas on 30th of November 2015, and a news article on RT.com entitled Sovereign Citizens See This Top Terrorist Threat by U.S. Law Enforcement by Brian Blanco on 5th of August 2014, and numerous other articles by stating they intend to murder any sovereign citizen without a trial and without due process by Obama's order followers, and then they proceeded to do exactly that. Hal R. Ray issued a findings, conclusions, recommendations of the United States Magistrate Judge, and Reed O'Connor approved it. And they're required to issue a finding of facts and conclusions of law, which means it has nothing to do with facts or law, which means they're deliberately and calculatedly legislating from the bench for their bill of pains and penalties and expose themselves to be the Pope's clergy. The Pope's clergy in the lower courts has presumed that the petitioner is a minor estate. The power to create presumptions is not a means of escape from constitutional restrictions, in spite of the fact that the petitioner says he's a living man and fails to be assessed to usufruct on everything and has for many years. The Pope's clergy, bill of pains and penalties are unconstitutional act and a nullity. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no offices, and legal contemplation is inoperative as though it had never been passed. An unconstitutional law is void, as is no law. The offense created by that is not a crime. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The Pope's clergy unfiled 78 criminal complaints that the petitioner filed into the case in support of the Pope's Federal Bureau of Investigation refused to investigate them in support of their targetedjustice.com agenda and weaponized Department of Justice, which is really just us, to refuse to prosecute the felonies against targeted individuals like the petitioner and hope the petitioner will exercise his right to resist their unlawful arrest and their unlawful theft of the petitioner's land and their forced slavery with lethal force if necessary, so they'll have an excuse to murder the petitioner, and they can say they killed another sovereign citizen terrorist in support of their war crimes agenda to take reprisals against anyone who thinks they have rights for their political beliefs, and in support of their communist handlers to eliminate private property rights, all of which is in support of the Pope's private bar guild and their Vatican handlers, who love satanic blood sacrifices to the Roman cult god Baal so they can pillage the fake money from the Treasury Direct account under GlennWinningham Fern under the Hague Convention concerning the administration of deceased persons concluded 2nd of October 1973. And the petitioner is not suicidal, but if the petitioner does turn up dead, this is deathbed testimony, and the Pope loves the shedding of innocent blood. Therefore, whether they slave the petitioner or kill the petitioner resisting their slavery, either way, it's a win-win-win scenario for the Pope. The Pope's clergy evidently intend to perjure their oath of office to the supreme law of the land under the Pope's Code of Law for the Pope's District of Columbia, now known as the Pope's United States Code 28 U.S.C. 453, and demonstrate they have no intention of being neutral or unbiased. The petitioner has filed bar grievances against 98 of the Pope's private bar guild clergy, some more than once, and they've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were all dismissed again. The petitioner has filed judicial complaints against more than 50 judges with the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. Only an Article 3 court can make decisions about life, liberty, or property, and this is Justice Thomas in this case in 2023, April 14th, which has been previously affirmed in numerous cases by the legislative inferior courts. Where a controversy is of such a character as to require the exercise of judicial power defined by Article 3, jurisdiction thereof can be referred only on courts established by virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal or, of course, in an executive officer, administrative, or executive board, since they're incapable of receiving it. Therefore, they're acting with no authority and malicious. Although probable cause may be inferred from malice, may not be inferred from malice. Malice may be inferred from lack of probable cause. And both the Pope's 97th District Court and the Pope's Northern District of Texas failed to be Article 3 courts because 14th Amendment U.S. citizens Catherine Phillips and her County of Montague accomplices do not get an Article 3 court, evidencing that even though they were not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity in support of their intent to be a legislator with their legislative usurpation of the bench. And their unconstitutional bill of pains and penalties because the Pope's County of Montague Ecclesiastical Municipal Corporation is in the Pope's owned and operated ecclesiastical municipal corporation called United States, which is operating in the Pope's District of Columbia under the Commerce Clause. and they're assaulting the petitioner with the Pope's minor estate. United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, making all needful rules and regulations respecting the territory belonging to the United States. Therefore, they failed to be an Article 3 court, but instead are Article 4, Section 3, and they're not competent to make a ruling about the petitioner's life, liberty, or property, which includes land, and their decision is a void judgment, and the judges in the lower court have exposed themselves to be the Pope's clergy. And the petitioner filed a notice of void judgment into the case, a true copy of which is attached hereto in the appendix, all of which is incorporated herein by reference in its entirety. Because the Pope's clergy in the lower courts love to find an excuse to ignore their oaths to the supreme law of the land, Article 6, Clause 2, the petitioner has been forced to file an affidavit of life and mandatory judicial notice of 12 presumptions. True copies of which are attached hereto in the appendix, all of each of which are incorporated herein by reference in its entirety. But the petitioner doubts it will make any difference because they're the Pope's clergy and have no interest in justice, but are instead engaged in justice for their Vatican handlers and are Satanists. You're of your father the devil, the lusts of your father you will do. He abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he's a liar and the father of it. But the fearful and the unbelieving and abominable, as the murderers and whoremongers and sorcerers and idolaters and all liars, shall have their part in the lake which burneth with fire, brimstone, which is the second death. The Pope's 1871 ecclesiastical municipal corporation operating in the Pope's District of Columbia is unconstitutional, as well as the Pope's minor estate and the Pope's private bar guild, because they're violation of Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they're laws respecting the Pope, the Vatican, and the Holy See, and they're subjecting the petitioner and all of the people they're dealing with to their satanic religious ceremony with their fake court cases, with their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking. The findings, conclusions, and recommendations of the United States Magistrate Judge Hal R. Ray in conspiracy with Reed O'Connor and Byers ruling in the 97th District Court are each a bill of pains and penalties, legislative usurpation of the bench against the named petitioner, and violations of Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, respectively. The Pope's County of Montague Ecclesiastical Municipal Corporation in conspiracy with the Pope's Comptroller of Texas and the Pope's Private Bar Guild in Texas and the Pope's Attorney with the rank of General are bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. And signed and sealed on red ink on the land of Texas under penalty of perjury under the laws of the United States without the Pope's United States Ecclesiastical Corporation. And that's the end of it right there.
Nice. It's not mentioned any body parts. I like that.
Yeah. So I've been trying to like tone it down a little bit, but I kind of get going. So we'll see. I'm pretty well done with it though. I'm thinking about sending it. I got the appendix. I got to start printing off stuff, and it's supposed to be printed on both sides, so that'll make the appendix or the whole thing smaller. Because some of those documents, I got to bring up about the common law court too. I got to bring up that too. Yeah, I got to bring up that.
And then it needs to be bound, correct? So how are you gonna bind it together?
One staple in the top left-hand corner.
There's an easier way.
Well, they don't actually want anything more than that. It says in the rules. It's very, very particular. So I got to figure out where am I going to put. Okay. I got to figure out where I'm going to bring up this my common law court judgment. I think right there is a good place.
Reading explains so much.
Yeah. Yeah, so I'm going to upload this file to the group. Right now, so I don't forget.
Does one give us permission to plagiarize the whole thing? Okay.
Well, you can't really plagiarize it. What I would suggest is you can use it as a template to do your own, or use it for other ones if you want.
Absolutely, brother. There's enough there to study and enough to.
So I'm going to upload all of the documents I have right now. There's a appendix, there's a petition, there's questions for review, and there's a table of authorities, and which are all required by the rules. I couldn't really hear what you were saying.
You sound like your mic sounded really distorted.
Oh, is this better? Is this better?
There you go.
Oh, okay. We were just throwing a funny there and plagiarizing. We wouldn't dare. But there's enough material there just to a very concise, such a well done document that there's enough there to study, just to study alone on all of the points made. We're not going to question one there's integrity, but the parts and the law forms and the cases and all of those there are just for edification to learn, so that we can have it, not so that we are just learning what is said in this document, but what is said in the whole context of the document.
Yeah, the history is surmountable,
Yes.
isn't it?
Yes, absolutely.
Yeah, that's what I was thinking too. The history of how the what did we want to call it? A mutation, the transfer from how it was hidden when Glenn was talking about, the Theophy relationship and how it came over to America, and everything's being, governed by the Pope, and we're not told that that's what it is. That's all in there.
Mm-hmm.
Yes. Yeah, it's well, that's why I put it in there. I'm kind of holding their hands. I'm sure they're going to do their own research. I'm sure that they will definitely, the clerk, somebody will do research on their end. They're not just going to take my word for it. But I'm trying to build as good a case as I can. I want them to the 1871 corporation and the minor estate need to go the way of a dinosaur. You know what I mean?
Mm-hmm.
And they picked this fight. I mean, I gave them plenty of warning. I told it that Catherine Phillips. I said, I've been to the Supreme Court 5 times, and you're next. And anyways, they say it costs $2 million if you bring a case to the Supreme Court and you pay the fee or pay for lawyers. They say it costs $2 million. And so, if anything, even if the thing gets, even if I don't win, it'll cost them $2 million at least, you know. And the sons of bitches, you know, don't get me going. You're gonna get me going.
I won't. I promise.
But I think they're going to be interested in it. I've had there's remote viewers that have remote viewed Congress adjourning for the last time. So I think it's because of this. You know, it could be because of something else, but I think it's because of this. But you know, again, that's my opinion.
May Glenn, in your opinion, do you think that the higher courts, I mean, do they comprehend usury and the, you know, exactly how it's being applied to us as living beings?
Well, they certainly do. They know also, though, that the reason we have usury, they know that interest is usury. And the reason we have it is because of Roman law. I mean, it's the Vatican. And so I'm not challenging all of the stuff that's Roman law, because the Roman law in America is everywhere. Okay. I don't know. You have a Federal Reserve note in your wallet. Okay. That's because of Roman law. You have a mortgage. That's because of Roman law. You have a loan on your car. That's because of Roman law. I mean, Roman law is literally everywhere. All I'm doing is I'm challenging the issue of the 1871 corporation and the minor estate and the bar. And I think that there'll be huge things. It'll be such a blessing for everyone. And you know, if you know, again, it comes down to a contract. If you want to go and get a mortgage, well, that you're volunteering for Roman law is what you're doing. But that doesn't mean that they can shove Roman law down everybody else's throat. You see what I'm saying? And that's what they're doing with me. There's no evidence in this case that I'm involved in Roman law, and there's no contract. And so they have to presume the contract doesn't exist.
Yes. So when we're talking about these contracts, see, I have one homeschooler, I have two private schoolers, and I have one that chose to go into a public school of the arts. And the education board is constantly sending me messages and emails that they want me to come and speak on behalf of my demographic, because I have the diversity of, you know, being across the schools. And so I can see from the attitude of the little ones and the ideas that come home who is getting exposed to what. And I have to sit there and really think, especially when they're asking me to speak on these things. Do these people even know what's happening? Like, you know, oh, it's a lot.
Well, you know, and as far as that's concerned, I mean, that's all coming from the legislature. I don't know what state you're in, but that's coming
New
from
York.
yeah. So that's coming from your legislature. New York is, you know, very corrupt, and so, uh, but it is, you know, civil law is Roman law, and so. So I guarantee you, if you file a lawsuit, you have to use the rules of civil procedure. Okay, that falls under Unidroit. I mean, it's just all over the place. But so you got to pick your battles, you know. And this is a battle that I think I can win, and so I'm willing to go to the trouble. You know, some battles you don't. First of all, is if you're not going to win, there's no use in fighting the battle, because it just uses up. It's a huge amount of effort, you know, and it's emotional effort too. You just, you know, you're better off just, you know, picking a different battle. And like, as far as I'm concerned, you know, once this case, I want to leave Texas. Quite frankly, I'm really tired of the police state in Texas, and you know, other states. I found other states are better, and so you know, I want to leave Texas, and and I want to get my stuff out of that Montague County, and then they can stick it up their ass. But meanwhile, I got everything I have is in a storage unit on that land that they were trying to steal from me, and so I couldn't just let that happen.
Absolutely not.
I totally get you. Thank you. I'm complete with my question.
What was that other document you were gonna show us?
Other document?
You said you were gonna go over your statement also?
Statement. That's a petition for writ of certiorari. I mean, I could go through the questions if you want. There's a bunch of questions that part of the rules require you to put together you have to have some questions for the court. And so, actually, I had a friend of mine going, he actually helped me with some of them because I had some questions, but he went and gave me some ideas on some more. And so I got to give him credit. So we'll go through the questions.
May I? We posted for the sister about the education and the curriculums. Loses trust. If one does a little research on loses trust, the curriculum for the school system was brought into being through this founders of the Lucis Trust, and I think there were 28 books, if I'm not mistaken, but we were just posting that as where the school systems are based and who's in charge of the the curriculum for the schools, and this is all across, from elementary all the way through college. It's a very interesting rabbit hole, to say the least. It's very it looks very benevolent in its presentation, but it's nothing but that. So I just posted that and hope that's okay.
Lucis Trust.
Mm-hmm.
That sounds
Yep.
kind of satanic.
Oh, does it? Yes, brother, it is. It's not rather. It is, and it's a good research from the foundings of that, and that's really where the basics of all the curriculum comes from schools.
No doubt. Yeah. And I kind of thought that they had changed the name of that thing because I knew that that thing has been around for a while, but people know that it's satanic. And so you would think that they would at least try to be a little discreet, but maybe not. Maybe they're kind of flagrant. Anyways, so what we're going to talk about now is the questions for review. This is, holy cow, there's that many pages of this? Oh, no, it's not.
Houston.
Yeah, so this is the questions for review. You have to have some questions. And so, and I'll probably have these reviewed again because I need to, the idea is to get them interested in looking at the case. You know what I mean? And so I want to have the questions. I toned the questions down from where they were, and so and then I have to shorten them too. Some of them are too long. Anyway, so is the 1871 Municipal Corporation 12 Stat 419 unconstitutional violation of Article 1 and Amendment because it comes from what is now the Vatican? And is the minor estate an unconstitutional violation because it was created by the Crown of England with the Sister KV Act of 1666, See, I left that one, but I could shorten it. Created by the Pope's Crown of England with the Sestake Act of 1666, and was the cause of the War of Independence, as evidenced by the Declaration of Independence and the cause of necessity for taking up arms issued by the Continental Congress in 1775, and brought into America with a code of law. See, I could just thin it down right
Was
there.
and brother, forgive me for interrupting, was the 1707 Sestake Act amendments, was that an amended version of the 1707?
I don't know. It started with the Sestake Act of 1666. That's the one that's well known. If there was an amendment subsequent to that, I mean, it's immaterial because this is where it started. Is the National Bar Foundation with all its subsidiaries in the various states an unconstitutional violation of Article 1 Amendment because the Pope's private bar guild, originating in the Pope's owned and operated city of London, claim immunity in an International Organization Immunity Act of 1945? Is it an unconstitutional violation of Article 1, Section 8, Clause 17 to use the minor estate to convert the petitioner's land from the land of Texas into the foreign district of Columbia? Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the FBI to refuse to investigate felonies by the County of Montague Municipal Corporation, to assault petitioner with the minor estate, to justify the theft of the petitioner's land, to get fake money in support of the communist agenda? See, I could probably thin this one down. I probably will. Is a judgment by the 97th District Court that makes a petitioner a minor estate a bill of pains and penalties? Is a judgment by the 97th District Court that makes a petitioner a minor estate a denial of due process under Article 5? Is a judgment by the Northern District of Texas that makes a petitioner a minor estate a bill of pains and penalties? Is a judgment by the Northern District of Texas that makes a petitioner a minor estate a denial of due process under Article 5? Is the refusal by the FBI to investigate 78 criminal complaints a denial of due process under the Article 5 Amendment? See, I like these ones a lot better because they're shorter. Is the refusal by the U.S. Attorney to prosecute the 78 criminal complaints a denial of due process? Is it a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the U.S. Attorney to refuse to prosecute felonies by the County of Montague Municipal Corporation, to assault the petitioner with the minor estate, to justify the theft of the petitioner's land and their extortion racket to get fake money in support of their communist agenda? See, I need to thin that one down a little bit. Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the controller of the Texas to authorize the County of Montague Municipal Corporation to assault the petitioner with the minor estate and render by force the petitioner's land for taxation, to justify the theft of the petitioner's land, to get fake money in support of their agenda to eliminate private property rights? Is it an unconstitutional violation of the Equal Protection Clause, Article 4, for the Secretary of the Treasury to refuse to dissolve and liquidate the Pope's minor estate in spite of the fact that the petitioner said he failed to care what they did with the fake money? They can put it up their rectal orifice because it was created by fraud and deception, and a satanic necromancy is being used to enslave the petitioner. Is the findings, conclusions, recommendations of the magistrate judge, which fails to be a findings of facts and conclusions of law, a legislative usurpation of the bench because it's involving a fiction of law which fails to exist under the Pope's ecclesiastical law, penalizing the petitioner, a named individual, with a non-judicial theft of land and a bill of pains and penalties? Anyways, yeah, I like that one. Is the findings, conclusions, and recommendations of the United States magistrate judge, which fails to be a finding of fact and conclusions of law, a denial of due process? Is the findings, conclusions, and recommendations of the United States magistrate judge, which fails to be findings of fact and conclusions of law, a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1? Is the Pope's minor estate and the Commerce Clause constitutional to violate Article 1, Section 8, Clause 17, a maximum of 10 miles square? So that's all I've got right now. So there's only 3 pages. But that'll give you an idea of the questions, and I don't think I want to have too much more, because again, the idea is to get their interest and get them to want to look at the case and to read it and accept the case. Okay, because what I'm going to do is I'm going to tell them they have no right to turn it away, because I am one of the people. Will Livingston's my 4th grade uncle, but I've done this before. I've been to the Supreme Court 5 times before. And every time, what's happened is the Solicitor General waives their right to respond, and then, because it takes away the controversy, okay. And so I want to make sure that they don't waive their right to respond. The Solicitor General has to respond for the government. Now, I'm not suing the federal government here. I'm suing the county of Montague. So I don't know how, they might waive their right to respond too. And so I want the Supreme Court to be interested and ask them to file a brief. I don't want them getting away with just waiving their right to respond. I can tell you that for sure, because I've had that happen before. And when they waive their right to respond, then the case gets dismissed, and it's a hollow victory, because I win, because they admitted everything. When they waive their right to respond, they admit everything. But it's a huge denial of due process. And that's why I'm putting it in here. Is it a denial of due process? Is it a violation of Article 4, Section 2, Clause 1 of the Equal Protection Clause? Is it... I want them to take this case. I want them to answer it. If they take it, it is going to be such a home run. Okay, if they take it, they're not going to take it to say, that the minor estate's lawful. Okay, it's clearly not, and so that's why I want them to take it. So, anyways, we'll see what happens. So this is the questions for review.
You're happy with that many questions?
Well, I gotta, yeah. Well, it's 18 questions. That's quite a few questions. It's 3 pages. I need to probably maybe thin it down a little bit. I don't think I want less questions, but I might, I don't know. I'm thinking. Let me look here.
18 seems to be a magic number.
Really?
I'd say too. Yeah, in the numerology
Really,
realm.
18's a magic number. 17's a magic number. That's for sure. I know 17 is. I'm not that much into numerology, so I can't say whether it is or not. But I know 17 is. 17 is the number. That's Q. Okay. So 17 is definitely a magic number. Matter of fact, maybe I'll cut it down 1 question. I'm telling you, there's something to that stuff. I'll tell you.
11 too.
Sorry?
11.
Yeah, 11's too few though. But 17, I like 17. I can certainly shrink it down to 17. 17 questions. Yeah, that's cute. That's what's that, Ruth, that the Bible. Okay, that's the that when you turn the enemy on themselves. That's all 17. 17 is yeah, for sure. 17 is definitely a magic number. So
we would second that motion. Yeah, we would second that motion. Yeah.
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 So yeah, so I got to figure out how I can thin it down to maybe 17. But so anyways, so those are my questions. Let's see what they're saying on YouTube. Yeah. So, anyways, so it's been going on for hour and 49 minutes. So I think that we ought to.
Wrap her up.
Yeah, wrap it up. Does anybody have any questions or anything?
Can one read that over again? We'll never get tired of when they're reading it.
Sorry?
I said, can one there read it over again so that it sinks in a little bit more? We've got another 2 hours.
Oh, yeah, right. I uploaded the Word files, so if you want to read them, you can go ahead and read them. They're uploaded
Oh, well,
to my page on We Are Law.
oh, absolutely, brother. We
So
already have a folder. We already have a folder for that.
yeah, so
Yeah,
you can get them off, download them, and then you'll have the files. And if you want to change them or make your own or do whatever,
study them. How about study them? Yeah.
well, it'll get you started. This stuff is stuff that I sit there and massage these things, and I've been the best defense is a good offense, and right now I
Mm-hmm.
think I need to go on the offense, and so I'm gonna have to. Um, I have found in my life that the more you attack them, the less likely they are to attack you, and it's back to the old. It's warfare. Okay, you got to make sure they never know where it's coming from next, and so. But I want this is one that I want the Supreme Court to want to hear and to want to answer, and I want it so that these County of Montague, Catherine Phillips, I want to make sure that they can't just waive their right to respond. Um, I know that the Attorney General is going to respond, or they did, um, in the Court of Appeals. But I want them responding in the Supreme Court.
So when are you filing all this? When is it going to be put in by?
Well, I gotta. First of all, I gotta send these questions for review to a friend of mine. He uses Grok to look them over, and but I'm probably gonna start. I gotta print a cover sheet, and then I gotta have the only other thing I need is the list of table of authorities. Yeah, I got to do the table of authorities. And he went and got Grok to make a table of authorities and the appendix. I got to fix the appendix. The appendix isn't finished. The table of authorities isn't finished. And so even if the petition itself and the questions for review are done, the table of authorities and the appendix are still not done. And then I got to do a cover. Yeah. Yeah, I got to do a cover. So I'm just taking a cover from one of my other cases, and I'm going to put it in there. And then
change the names to expose the perpetrators.
Oh yeah. The other one, I had a table of contents that was separate, and I don't need that. But yeah, this is. I got to change the certiorari cover. Matter of fact, I'll upload the one that I have, but it's going to get changed. I'll upload it to the group, and then you'll see what the cover looks like. But it's going to get changed.
There's no requirement on weight or anything of paper or anything like that.
Oh
What
yeah,
about length? 11 by 14, right?
8.5 by 11. 8.5 by
Okay,
11
that's
and
cheap.
printed on both sides. It depends on what rules you use. I mean, there's a couple different ways you can do it, and but I'm doing it. You know, I'm not doing it. I'm just I'm not a lawyer. That's the first thing I say. I'm not a lawyer, and so that cuts me a lot of slack. Let me tell you that. And so yeah,
Yeah, I like the way you just leave it as that. You don't go on to say that you're an attorney of fact or,
I'm not a
you
liar.
know, ramble.
I'm not a liar.
And attorneys don't learn any of this history in school. What they learn is policy and statute. So this is an education for some of them.
You know, I'll bet you they already know. You know, these attorneys are just scum. Yeah, don't get me going. The Catherine Phillips. Yeah, these attorneys are just scum.
The informer would call them vermin.
Yeah, right.
Vermin. Yeah.
They're foreign agents of the Vatican. They're yeah. Don't get me going.
Have you looked into the new pope that's from Italy at all?
The what?
The new pope that was
Well, he just got
appointed.
convicted by the International Common Law Court. Is that the guy you're talking about?
He was just anointed in, well, upon the death of the last one. When was it? April?
He just got convicted by the Common Law Court.
There we go. Is that why there's such an uproar in Italy?
Sorry?
There's such an uproar in Italy right now about
He's
the
not from Italy. He's from Chicago.
Yeah, he's from
Chicago.
Chicago.
Oh, I thought he was from Italy.
No,
He's from Chicago.
he's from Chicago. Yeah, yeah. He just got
First
convicted
American.
of being involved with the Ninth Circuit satanic cult.
So you won't be serving him.
No, no, I ain't gonna serve him. Yeah.
Well, he brought Chicago to Italy then.
I guess, eh?
No, he lived in South America for years.
Was he in South America? I thought he was. I know he's from Chicago, but you know he could have.
40 years, Peru or something.
Well, his name says that he's Italian.
Yeah, that's interesting.
Danilo.
Pope Leo the 14th.
There you go. He has Italian background.
Leo the Khazar. There used to be one called Leo the Khazar.
Yeah. So,
Well,
anyways,
yeah, we're exposing the corruption. You're doing a good job. So I guess I should ask if there's any more questions, and Claude, let you leave off for the Thanksgiving weekend. You're gonna have turkey this weekend, aren't you?
This has got to be your Thanksgiving. It's not here.
I forgot you defected long ago. So you don't even enjoy a turkey day?
We do. In about 6 weeks, we'll have it. You could always come down for a
Okay,
visit
well,
and have Turkey Day with us down here.
there you go. Well, I'll wish you a happy Turkey Day anyway, because it is that for us up here, and that'll give you time to prepare for your Turkey Day. And
There you go.
hopefully, I will be in the south where it's much warmer than the conditions that I currently have to endure. So, I will attend that meeting next week. Thank you for bringing that to my attention. And if there's anything else, I'll let you go.
That's on Sunday.
Oh, okay, good point. Good point. I thought it was during the week. I'll check the email.
Check the email. It's on Sunday. And, it's just, everything right now is rumors. And so I don't put much stock in anything. It'd be nice. It'd be really nice if that's true. I'll tell you, I will be so happy. But my attitude is that it's in God's hands. If God wants that to pan out and to work out and to do what they're talking about doing, then I blame it all on Him. And so that's my attitude.
He won't let that happen.
He won't let it happen.
He has to let it happen. We
Yeah,
want
he
to
does. It's in God's hands. If He does let it happen, it's all His fault. And if it doesn't happen, then it's not meant to be. That's all. I'm not worried about it. But I can tell you that I've always known, and I'm not sure how it's going to happen, but I've always known that just before the end, I would come into more money and I'd never know what to do with. And I don't know how it happens or anything. I always thought that maybe I'll get that Treasury Direct account. Because I had some dreams about that I don't like to talk about because I don't want to manifest anything. But some things happen, and I go and look at my bank account, and there's it's just a huge amount of money in there. So I don't know if that's what's going to happen. I have no idea what's going to happen or how it's going to happen. And quite frankly, if something happens with exceedingly, it won't go in the bank. I guarantee you. I'll have it in a private wallet is where I'll have it, and I'll try and spend it directly from there.
Yeah, well, I'll make sure that the wallet is secure too, because they all want facial recognition now. Up here, anyway.
Yeah, they don't, not here, and I don't think that's going to happen here. Matter of fact, they're saying that even that Trump is going to they're gonna have their thumb on things, but they're not going to have a CBDC here. So, what I'm hearing is that we're going to be in war by Christmas. And so how that all plays out, matter of fact, what I heard is that there's civil war. It's going to be a civil war. It's going to start in Chicago, and there's some people saying it's already started. I don't know. I know that things are getting ugly in some parts of the country. I know that it's perfectly fine here, and I want to head for the hills anyways. Even right now, the way it is, I want to get out of the city. And but it's relatively peaceful here. So I don't know what's going to happen or how it's going to happen. My attitude is when this happened, when I got arrested, I had this feeling come over me that this is just the most wonderful thing that's ever going to happen, and it's going to turn to my advantage big time. And so far it has. But I gotta. That's why I'm doing this, because I want to. Again, the best defense is a good offense, and so I want to make sure and get this thing filed, and we'll see what happens from there. But I just had this feeling come over me, and then when they dismissed everything like they did, I mean that just confirmed, that I just had this feeling that this is just going to be the most wonderful thing in the world. And when we were in the jail, there was some Christians in there, and almost every night we had a prayer circle, and they'd go around the circle. What are you grateful for? And I tell them, I am so grateful for all the wonderful blessings that are coming. The scriptures tell us that the Lord's going to turn everything to our advantage, and I am so excited about what's coming. and I still feel that way. And all it's doing is just everything that happens is just more reason to believe that it's just gonna be wonderful. So I
Yeah,
am.
the manifestation of it all, right?
You bet, you bet. So all right, well, if that's it, we'll see you guys next week, same time, same place, same channel.
Sounds good. Okay, well, you have a good weekend, and I'll be grateful for you this weekend. How's that?
Yeah, check out that link I sent you, and I'm going to be on there, and we'll see
Okay.
what happens. I don't know. I don't know what's going to happen. This is just a rumor that's going around, and if it comes through, then that's great. If it doesn't, it's what's meant to be. You know.
Yeah, well, I'll let you know what's going on with that other company I was mentioning. So I'll
Okay.
talk to you about that later.
All right.
All right.
Take care.
Take care. Thank you.
Many
All
thanks,
right.
brother.